And law enforcement use thermal imaging like this to see what's inside a person's home. We talk technology and what all that implies next on Legal Updates. And hello everyone and welcome to Legal Update. I'm Rob Willman. The case is called Kyllo versus United States. It took 10 years to reach the Supreme Court, and it discusses the use of technology in law enforcement. The question at hand, does the use of thermal imaging aimed at a private home from a public street to detect heat from inside a home constitute a search? 10 years before the case goes to the Supreme Court, government agents were using technology that was in its infancy. Still, thermal imaging was and is a great tool for law enforcement, but using heat-sensing devices without first obtaining a warrant for such usage was deemed unconstitutional by the Supreme Court. For years, the United States has used thermal imaging for military use. Finding the enemy was easy with heat-seeking technology. It wouldn't be long before law enforcement hopped on board, too. In 1991, Agent William Elliott of the United States Department of Interior thought there was marijuana growing in a row of homes called a triplex. He used technology similar to what you see here to determine if Danny Kyllo was using lamps to grow marijuana. Agent Elliott scanned the residence from his own car from across the street. In only a few minutes, he determined lights were being used over the garage. With the aid of thermal imaging, utility bills, and tips from informants, law enforcement obtained a warrant and found an indoor growing operation involving more than 100 plants.
The key point is that our home is a sacrosanct place in our American society. And it's been that way probably since, well, certainly since the founding of the United States, but it has been that way since the Code of Hammurabi, that people's homes are considered fairly much their sanctuary. And the issue for us is always, what is the line of privacy when technology can break down the walls completely and make them irrelevant so that we can detect molecules coming through the walls, and the walls are no longer a marker of privacy, but in fact a fountain of information.
And the courts agreed. By a 5-4 margin, the Supreme Court ruled that the use of thermal imaging aimed at a private home from a public street constitutes a search within meaning of the Fourth Amendment. Ken Lerner represented Kyllo. He argued successfully that technology like thermal imaging leaves the population defenseless against such surveillance.
Justice Scalia has always tried to interpret the Constitution in the way that the original framers of the Constitution conceived of the right to the privacy rights that are embedded in the Constitution. And so he was looking at the home as it was traditionally seen, and whether the technology is really doing the same thing as someone physically intruding into the home. So it is somewhat a guessing game, of course. We don't know what the framers would have done had they known about airplanes and telephones and microphones and things like that. So we can only use our best judgment, and there's always a swing on the Supreme Court about whether we interpret it based on today's contemporary standards and notions of privacy, or whether we interpret it based upon what the framers originally intended the privacy rights to be.
Justice Scalia and those justices that joined him, and that's the majority opinion, said this is the home. And if the police gather information about what's going on inside the home, that's prohibited by the Fourth Amendment. So where they stopped was at the wall of the home. And they said that's a search, and a search must be supported by a warrant with probable cause. They didn't have it here, therefore it's a bad search. The dissent, on the other hand, kind of looks at it in two different ways. First, they say it's not a search because the police officers gathered no more information than anyone who's walking down the street could have gathered, assuming that there was some rain or snow and it would have been melting or drying quickly because of the heat emanating off the wall from the marijuana growing operation that's inside the garage there, above the garage. So the first, they say there's no search because there's no reasonable expectation of privacy, which is our test for a search. Secondly, and they don't do this very explicitly, but the second part of the dissent is essentially saying, even if there was a search, it was a very reasonable search, because we have this great law enforcement interest in getting to drug dealing and growing of drugs and passing them on in public. And we have a very minor privacy interest here. Again, all we're detecting is some kind of extraordinary heat emanating from this part of this house.
Earl Martin